Well, good morning, everybody. My name is Brody Smith. I'm an attorney at Schoeneck King. I'm located in the Syracuse office. We have offices all over New York State that practice in a variety of different disciplines. Today, I'm going to be talking about SEQRA. SEQRA is the acronym that lawyers in New York State use to describe the environmental review process that's required before an agency can undertake an action. So what SEQRA really is the obligation to consider the impacts of things like construction before a Board of Education or any unit of the government decides to go forward with the project. My practice has involved litigating SEQRA issues, advising government entities and school districts about how to comply with SEQRA, and then also representing developers before zoning boards and planning boards for about 20 years. And over that time, you see changes in the way that SEQRA is interpreted and in the way that it's applied. But the one thing that remains constant is it's very important. It's a complicated statute that has a lot of regulations that go along with it. I'm going to walk you through the structure of those things. It also has a lot of guidance. It's good news and bad news. The good news is there's a lot of resources you can use to help you understand SEQRA and the different procedures better. But the bad news is there's a lot of resources. So there's a lot of things to read and be potentially confused by. And, I think the best thing to do in those situations is to reach out to counsel for help in understanding those issues. So we'll move to the first slide and talk about the overview of what we're going to cover. First, we'll talk about the origin and purpose of SEQRA, and specifically its role in the context of the state education department, what it was before, what it is now, because that relationship between SEQRA and school districts changed quite a bit about 20 years ago. We'll talk about SEQRA concerns that are unique to school districts. And then we'll spend most of the time going through the process of SEQRA. I'll tell you a little bit about some key definitions in the statute that'll help you understand some of the alphabet soup that you hear so often, and segmentation, enforcement, and we can go through some examples. So before I move any further, SEQRA is the phrase that you hear people use to refer to this process. It actually stands for the name of the statute, the State Environmental Quality Review Act, SEQRA. You often see it abbreviated SEQR, and so that's where the nickname SEQRA comes from. But if you hear someone refer to it as SEQRA, we're talking about the same thing. They're just two different acronyms for the same thing. So moving on to the next slide, where is it found? So there's three legal bases for the SEQRA requirements. First, you look in the environmental conservation law. That's the statute, and that was passed in 1976. The laws of the state of New York are divided up into different volumes, and the volume where you will find the SEQRA law is called the environmental conservation law. The environmental conservation law is broken up in different articles. Article 8 is all SEQRA. Prior to 1976 and the passage of SEQRA, there was no obligation by the government to consider environmental impacts before deciding to build something, or before deciding to go forward with a certain policy. There was no legal obligation to even consider how that would affect the environment by virtue of making that decision. So there was a movement in the 70s across the country in federal government and in state governments to improve environmental laws and to try to make them reflect societal values, concerns, and to address environmental issues that were becoming increasingly alarming at that time. So what the state legislature in New York did is they passed this law. Now, there's a, I think, a misunderstanding in the public realm that, well, I don't like a project, we're going to get a group together and we're going to sue them under SEQRA and stop it. Remember, the fundamental purpose of it is to make the government consider environmental impacts before making a decision. What SEQRA doesn't say, and I think people misunderstand, is that if a project will have a negative impact on the environment, you can't do it. It instead provides procedures, which you then find in that second bullet, part 617 of the codes, rules and regulations, of to make sure that the government considers those things, make sure they think about those things, they weigh those things, they weigh the benefits of a project against the potential negative impacts of the project. And there could be many negative potential impacts. It could be expensive, it could be unpopular, but the one that SEQRA is concerned with is impacts on the environment. So it just is an obligation and a framework that requires the government to weigh those things. So the second bullet, the regulations, give you the detail. The statute says that this is going to be required by law. The regulations then provide you the framework in part 617 of how you actually go through and apply that law. It gives deadlines for taking certain actions, which we'll go through in detail. It gives you lists of certain types of activities that are going to require you to use one form versus another form. It's going to tell you if you're required to study something further in a document called an environmental impact statement, what time frames you're going to have to follow in terms of giving the public notice of it and the opportunity to comment, et cetera, et cetera. So the statute creates the obligation to consider impacts on the environment. The regulations give you the procedural details as to how you're going to do that. And then finally, the third point in this slide is judicial decisions. Nothing about SEQRA is very few things about SEQRA, I guess I should say, are just so clear that everybody agrees as to what it means, because it's a complicated process. It's both substantive and procedural. It touches and concerns virtually every single construction project in the state of New York in one way or another. And so there are mountains of judicial decisions that interpret the meaning of the statute and the regulations. So oftentimes, you read the statute and you say, okay, I have some sort of obligation here, but I don't know what to do. You read the regulations. Okay, this gives me an idea of the procedural steps I need to take, but I don't really understand what to do in this situation that seems to be between two things described in the regulations. Then you go to the case law, and the case law will tell you, where there have been disputes. The judges write decisions, and those decisions help you interpret mainly the regulations, what they mean and how they should be applied. So the next slide talks about the golden rule. If you want to try to boil SEQRA down to its very essence, it is that no agency involved in an action may undertake, fund, or approve the action until it has complied with the provisions of SEQRA. So there's a lot there. I'm going to talk to you a little bit about the definition of agency, but I think by virtue of the fact that we're all here, that a Board of Education, for the purposes of this statute, is considered an agency, so this rule applies to you. Involved is a loaded word. Involved versus interested. These are all defined. Involved, it's an oversimplification, but involved basically means that a permit is required from that particular agency. So one application to build a structure could involve a lot of different agencies. You might need a wetland permit from the Army Corps of Engineers. You might need approval from SED. You might need a municipal approval, though school districts are immune from local zoning and planning processes. If you're interconnecting with the municipality's water or sewer system, for example, that's an involved agency. You're going to name the elected board of the municipality where you're located. If there's a historic structure on the site or adjacent to the site. The state parks, SHPO, state parks agency may be an involved agency, on and on and on. There could be lots of involved agencies because oftentimes one project will require permits from different agencies, and any agency that has to issue a permit is considered involved. There's also interested agencies. Interested agencies are agencies that merely comment that you have a requirement to notify, but won't necessarily have to issue a permit. Action. We'll talk in more detail in one of the future slides as to what an action is. It's very broad. Certainly, your capital projects are an action. And then undertake, fund, or approve. Again, broad language. Whether or not the school district is actually initiating a construction project, it's still that's clearly a SEQRA action, but there's also other actions that may not occur to you outside of the realm of your capital project. If you think about policies that that the school district's going to pay for, it's going to implement, or is going to approve through a vote, potentially all those things could have SEQRA impacts. You don't have to build something to affect the environment. So that's something to keep in mind. I think everybody on this call's keyed into the idea that I gotta may not know exactly what to do about SEQRA, but I gotta do something about SEQRA every time we have a construction project or a capital project. But one thing you may want to consider is that action is not defined as building something. Action is defined as any time an agency undertakes, funds, or approves an action. And many actions could have potential impacts on the environment that don't involve brick and mortar and don't involve digging in soil. So that's something you should consider too. Okay, let's go to the next slide. So there are substantive and there are procedural requirements that must be followed when you're complying with SEQRA. Substantive means the purpose of the statute. We just talked about the golden rule. You got to actually, consider impacts on the environment, right? But there's also procedural requirements that, tell you the sequence of events you have to follow, the forms you have to use, things you have to consider, when you have to write something down, etc. Starting with substantive, you have to consider and weigh environmental impacts together with social and economic factors. Weigh environmental impacts. What does that mean? Well, weighing environmental impacts involves going through a methodical and explicit, overt process where you discuss the potential impacts of a project on the environment before you take a definite course of action to go forward with that project. So here's another misapprehension that I think you often see. You'll be under a lot of pressure to get through SEQRA for a capital project, for example, and you'll be worried that there'll be opposition. There'll be opposition from neighbors who are worried about stadium lights. There'll be opposition from the business district, down the street that's worried about rerouting the bus traffic. There'll be opposition from neighboring property owners who are worried about stormwater changing its course based on your construction of a football field, right? There's a temptation, and I see this often, let's not emphasize or let's not mention this particular potential impact because we're worried about encouraging that opposition. It's actually the exact opposite instinct from a litigator's point of view than you would want to have in establishing a record that you could defend. If you think there are potential impacts, think back 2 slides ago. Does SEQRA say if there's negative impacts on the environment, you can't go forward with your project? No, it says you have to consider those things. So if you think there's opposition, if you think there's potential impacts, you get those into the record. You get that discussion out in a public hearing. You have people, you encourage people to comment, and then that gives your engineers and your professionals an opportunity to respond to those comments in writing before you make a decision. And you create a substantive record that if this were to go to court, you want to put the judge in a position it's like, well, I may not agree with their conclusions, but you can't deny they didn't think about stormwater. Here's a report from their engineer directly responding to all these comments in the community about stormwater. The comments in the community say it's going to have a negative effect, but look, there's an engineer report that says that they've created infrastructure in terms of stormwater, detention ponds or treatment or whatever that's going to prevent any impacts on the neighbors. They did what they're supposed to do. They considered it, right? So that's very key, to try to resist that instinct to gloss over or to avoid issues. You want to address those issues head on. You want to address those issues whenever possible in writing in the record. And that's going to put you in the best position to win in the event of some sort of litigation. The second bullet talks about determine whether an action will have a significant adverse impact on the environment. That's really, for most of your projects, that phrase is the name of the game. Significant adverse impact on the environment. You can think of it in broad strokes. There's sort of two overarching steps to SEQRA, right? The first step is a process that ends in you making a determination of significance. And those of you who've had experience with capital projects, probably, that's really what I want to think about. That's really what I want to talk about. How do I get to that quote unquote negative declaration? A negative declaration states that, after looking at these potential impacts on the environment, we feel that we've gathered enough information. We've got consultant reports, we've got advice from our engineers and our architects, and we just don't think this project's going to have a quote unquote significant adverse impact on the environment. And if you get to that decision, then you stop, you end SEQRA. That's called a negative declaration. A positive declaration is, well, we looked at this and we think there is the potential for a significant adverse impact on the environment. Then the statute requires you to go into step two being the preparation of an environmental impact statement, which is a more detailed study of a specific issue that was identified below in step one. And that requires you to, study that in greater depth. It involves scoping. It involves public comment. It's a process that takes, several months, at least 6 months in my experience. And so that environmental impact statement process is what follows if your board issues a positive declaration. So that phrase, significant adverse impact on the environment, is going to dovetail which way you go. Negative declaration, we're done with our consideration of environmental impacts. Positive declaration, we got to study it more. This is going to take a little longer. We're going to have to spend a little more time and money to really get our arms around a particular issue. And then the third bullet is agencies must avoid or minimize any adverse environmental impacts to the maximum extent practicable. So SEQRA does create the obligation. If you issue a positive declaration, if you decide there's going to be significant adverse impact on the environment, you do have to take whatever steps are practicable to minimize those impacts if you decide to go forward with your project. Again, because there'll be negative impacts doesn't mean you can't go forward with your project, but if you issue a positive declaration, you do invoke an obligation to try to address some of those impacts so that they, in the context of the project going forward, they're minimized in some way. So the next slide talks about procedural requirements. That's the preparation of documents, filing, distribution, and publication of certain documents and specific time periods for certain activities. I talked to you about that structure of statutes, regulations, cases. Well, SEQRA, there's another layer after regulations. There's a bunch of forms that are promulgated by the New York State Department of Environmental Conservation. And those forms are supposed to, if you follow the forms and you follow the directions in the forms, the intent is that's going to satisfy your procedural obligations under the regulations. So what do I mean when I say that? there's something called the environmental assessment form. It's broken up into 3 parts. And the intention of the environmental assessment form is to get you to that either pause deck or neg deck moment, right? The first part of it gives you background about the project. Second part is an issue spotting exercise. Third part is supposed to help you make a determination of significance. And so those documents, it's important to know how to use them, or hire someone who knows how to use them, and to complete them in the instance of every action, because that's going to be your best protection against a lawsuit. That's going to be your shield to show that you followed the procedural requirements, that you went through and you provided all the information required by the environmental assessment form. You checked all the boxes, and then you followed the legal, you answered the legal questions that are baked right into the document. Filing, distribution, and publication of certain documents. You're going to have obligations in certain instances to publish notices of a public hearing in local newspapers, to publish notices of certain decisions that you make under SEQRA in something called the Environmental Notice Bulletin, which is a website that the DEC maintains. And then in some instances, you're going to be required to send information to other government agencies and notices and that sort of thing. So that's what that refers to in terms of procedural requirements. And then specific time periods for certain things to happen, particularly when you get into that second step and you have an environmental impacts, you have an obligation to prepare an environmental impact statement, which people commonly refer to as an EIS. If you're doing an EIS, that's a highly regulated activity where you have to publish certain notices, you have to have certain hearings, you have to give people an opportunity to comment either in person or through writing, and there's timeframes to do all those things. And so those timeframes are laid out in the regulations as well. So in the previous slide, we talked about substantive requirements. What's the point of the law? What are we trying to achieve? But there's also these procedural requirements, and case law indicates that your approval could be nullified or voided for violations of either substantive or procedural missteps. Some procedural missteps can be fixed, but the procedure can't be shrugged away. There are many cases where procedural defects will require you to restart the SEQRA process and do it again, which can be very expensive and inconvenient in the context of a capital project. The next slide talks about the role of SED. A long time ago, SED accepted responsibility for SEQRA, and your lives were easier. SED was the quote unquote lead agency for all your projects, and you didn't have to do it yourself. SED took on the obligation of SEQRA. That changed, and that's not the reality that we live in now. Though SEQRA was an invisible process to school districts, it is now your legal obligation. SED, changed that policy, and instead of all SEQRA for all school construction projects all over the state magically happening somehow in Albany, it now happens at your Board of Education meetings, and your district is responsible for undertaking SEQRA. The next slide, I think, provides some time frame for that. SED amended their own regulations in November of 2000. So it's been 23 years since that happened. But I know, a lot of times, the reason I bring it up is a lot of times there's, gaps between major capital projects, and you may be, talking to mentors, or even, if you were working on these sort of issues prior to 2000, you may be thinking like, well, I don't have to do SEQRA. We've done this before and we didn't have to do that. Well, you do now. The school districts have to comply with SEQRA for all their acts, for any action that requires SED approval. And any failure to comply with SEQRA can nullify a project. What that means is all these SEQRA documents that we're going to generate, they're going to go to SED. And if there's a person at SED whose responsibility is to check that SEQRA was complied with. So in addition to worrying about like opposition groups suing you for doing SEQRA wrong, you've got sort of the added check on school district actions. If SED doesn't think you followed the right SEQRA procedures, they're going to kick the documents back to you and ask you to do it again. And again, I know when you're going to referendum for bonding or that kind of thing, timeframes are important, and so you want to follow, satisfy the requirements of SEQRA the first time, so you don't have SED, question what you did and require you to start over. The next slide talks about some of the guidance. Guidance came out following that decision, imposing obligations on school districts from SED. So there's a guidance document that from August 2001 that we reference in a lot of the resolutions that we write. And it does create some SEQRA concerns that are unique to school districts, above and beyond the general obligations under the statute. So sometimes people refer to that as SEQRA plus when you're trying to follow the SED's rules about complying with SEQRA. The next slide tells you a little bit about what those are. First, SED must be copied on all your SEQRA correspondence. So when you're sending out notices and that sort of thing, you have to send it to them too. To receive a building permit, SED requires evidence of coordination with involved agencies and appropriate interested agencies. So we'll talk about in a moment, the lead agency letters that you send out and that sort of thing. That's that evidence check I was telling you about. They require consultation with SHPO on projects, even if they're type 2. Type 2 actions have less of an obligation to go through all these SEQRA steps, but SED wants you to consult with them, with the state parks agency on basically on historic structures and that sort of thing, even on type 2 actions, which you don't have to do, others don't have to do. SED requires consultation with the DEC on all type 1 or enlisted actions. And that's not surprising. Most of your actions are going to require some sort of stormwater permit from DEC anyway. And then you can't just declare something type 2 in a board meeting with verbal motion. They're going to want a resolution, a written resolution explaining why something is type 2. I'll explain type 2 in a moment. That is a lessened obligation under SEQRA. When projects are below certain thresholds, you don't have to do as much SEQRA. The next slide talks about referendums. Conducting a referendum before SEQRA is completely prohibited. What you'll find is the referendum could be declared null and void. And more than that, you're bonding for all these projects. Your bond attorney is not going to issue the letter to the bank if your SEQRA is faulty. So it's something you got to do before you get to the referendum, before you pass a bond resolution. SEQRA comes first. Next slide. Scheduling a referendum before SEQRA is completed presents a risk. The act of scheduling could potentially be construed as an action. So the case law says that SEQRA needs to be done at the earliest possible time. So that means that you can't have Board of Education meetings where you take a vote and, take a definite course. We're going forward with this project, before you engage in SEQRA. So it says there at the bottom, remember the golden rule. It's safer to wait until SEQRA review is complete before you schedule that referendum. You don't know how long it's going to take. You don't know if there's going to be hiccups. So you want to finish SEQRA in an ideal world before you schedule that referendum. Next slide. Essential SEQRA definitions. I'll go through these quickly because I think we covered a lot of them and up top. But what's an agency? Well, an agency includes a school board. Remember, involved agencies are agencies that have jurisdiction to fund or permit. Interested agencies don't have that jurisdiction. You're not asking them for money. You're not asking them for a permit, but you're consulting with them in some way. And then the lead agency is the involved agency that is responsible for complying with SEQRA. Generally speaking, a lot of your projects can be type 1. That means that SEQRA is going to be coordinated. When I say coordinated, I mean you're going to do it once. The school district is going to be the lead agency. You're going to do SEQRA, and everyone else, all the other agencies that issue permits, will not be required to do their own SEQRA because you did it once. You did it the first time. So that's what a lead agency is. in the event that you're engaging in coordinated review, that's the agency that actually goes through SEQRA, and the other agencies rely on your conclusions in SEQRA for a negative declaration, for example, before they issue their permit, and they won't go through and do the whole thing themselves because the lead agency did it once. There's the potential for uncoordinated review in certain circumstances where each agency will do their own SEQRA, but I think it's obvious to everyone there's sort of an inefficiency to that. So coordinated review is preferred. The next slide is what an action is. We talked about actions, a very broad definition. It includes physical activity, which I think is obvious, but also planning and policy making activities that could affect the environment or commit the agency to a definite course. Adoption of agency rules, so rules and regulations and procedures that could affect the environment that the school district adopts, not just construction projects, could trigger the obligation to follow SEQRA. Next, the environment is not just birds and trees and flowers. It involves other things. It involves, intuitive things like air and water, but also SEQRA encompasses things like noise, impacts on farms, agriculture. There are archaeological resources, in terms of things in the ground. There's historic and aesthetic resources, architecture, historic buildings, etc., that SEQRA considers. It also considers impacts on the community and human health. So changes in the character of a neighborhood, changes in growth patterns, infrastructure, transportation, all those things. It's exceedingly broad. SEQRA encompasses concerns under all those categories. The next slide. What's the first step? Well, what you have to identify whether the proposal is an action. So capital improvement projects are actions, physical construction, including new construction expansions in action, acquiring new property, even before you decide to build something on it, that is an action. Closing a school is an action. If you think about it, it's going to change traffic patterns. It's going to have a lot of knock-on effects, even though you're not building something. That's an action. And then maintenance, repair, and renovation is potentially an action under SEQRA too. Next slide. So, thinking about your average capital project, think about all the pieces. There could be the alteration of sports fields. There could be additions to buildings, changes to parking lots and reorientation of driveways, removal of trees, the excavation or regrading of the landscape. Think of all those pieces of things that, school districts have to do to keep campuses up and running. They're all potentially triggering obligations to follow SEQRA. Next slide. Break some of those down. Field improvements have potential stormwater impacts, lighting, new building additions over certain thresholds are going to require you to do SEQRA. Changes in drainage, renovations in the interior of a building will trigger even that will trigger SEQRA obligations. Next slide. Specifically listed activities might be considered type 1. I'm going to talk about 3 categories. Type 1 are bigger projects, and they're going to trigger your obligation to do a bit more SEQRA. So physical alteration of 10 acres or more for new facilities, 5 acres for just expansions. Purchase and sale of more than 100 acres, so acquisition of a large amount of property, or anything that doesn't trip those thresholds that would otherwise be considered unlisted, but it is you're altering something that's on the National Register of Historic Places, or you're contiguous to a structure like that. Those are going to be referred to as type 1 actions. The impact of something being a type 1 action is you're going to have to fill out something called the full environmental assessment form. It's a longer form, where a short form would be available if it was something under those thresholds. Next slide. So, the first thing you do is you talk to your architect or your engineer, and, in this instance, we've got a new driveway for one of our clients to a loading bay. You would calculate the acreage. Does it trip that 10-acre threshold. And if it doesn't, it's not type 1, and you're going to fill out shorter forms and have fewer obligations. If it does, it's type 1, and there's certain things you have to do. Next slide. Well, sometimes, you look at how much land is being disturbed. That driveway probably was not 10 acres, but you look at sports field alterations and you get there pretty quick. And so this is an example of, something that you're disturbing more land. It's not just the field, it's the track. It's not just the track, it's the stands. It's not just the stands, it's the track and field facilities surrounding it, etc. Next slide. And then the big projects are obviously type 1. Here we're building 1, 2, 3, 4 different fields, a new basketball court, tennis courts. We're way into type 1. Easy answer on something like this. Next slide. Type 2 actions, it's a list of things that are considered to be assumed not to have a major environmental impact. So anything on the type 2 list are routine activities, including expansions of less than 10,000 square foot, maintenance or repair involving changes that aren't substantial changes to your existing buildings, but you need to replace things, and just collection of information, studying things. Those are considered to be type 2. If you pass a resolution saying something's type 2, you don't have to fill out the environmental assessment form. You don't have to do an EIS. You don't have to get to a negative declaration. If it's on the type 2 list, you pass a type 2 resolution and your SEQRA's done. Next slide. So, the stairs need to be replaced. Well, if you're replacing them with stairs in the same location, that's that replacement. You're going to use this replacement type 2 get out of jail free card as often as you can. If your project it just involves replacing the same thing. Now, it doesn't have to be stick for stick. Maybe before there were 3 stairs and you're reorienting it, and now there's 10 because changes of it, or there was one type of stair and now it's a different type. That's okay. It could still be replacement. It doesn't have to be exactly stick for stick. But there's some questions that you can talk to your attorney about as to whether or not they're going to qualify for replacement or if it's actually a new project. Next slide. Oftentimes, that's replacement of brick and mortar, windows, even a roof. Next slide. HVAC systems could potentially be type 2 if the whole project just involves replacement of that. Next slide. Unlisted actions is everything else. You're either on the type 1 list where you have enhanced obligations, you're on the type 2 list where you have virtually no obligations, and everything else falls into unlisted, and that's your third category. Next slide. Step 3 is completing that EAF that we talked about, the environmental assessment form. If it's a type 1 action, you have to use the longer form. It's called the full EAF. If you're doing SEQRA on an unlisted action, you can use the shorter form, the SEAF. You begin by completing part 1 of that of the EAF, where you provide background. Your engineer would fill that out usually, or your architect provides background about the project that will help the board evaluate the impacts. Next slide. This is what it looks like. This is part 1 of the full EAF. You can see it's small print, but the first page is you're describing the project. You're saying who you're going to contact, and then I picked a page later on, and it's long. This particular page deals with land uses. How much forested land are you going to remove? How much meadows are you going to remove? How much agricultural lands are you going to remove? Will the project involve the generation of waste that needs to be disposed of? How are you going to dispose of it? This is the background information, part 1 of the EAF. Next slide. Part 2 of the EAF has 18 questions. They're broken up into different categories. This is one page of it. This one's dealing with the impact on land. If you're going to have, most of your projects going to impact on land, where you check yes, and then you'd have an obligation to go through the sub questions. If you, after going through the sub questions, believe that the impacts will be either no impact or a small impact, then you don't need to you don't need to look at that issue any further. If you believe that there's a moderate to large impact on any of those sub-questions, then you have to consider anything that you check moderate to large in part 3 of the EAF. Next slide. Coordination at the beginning, I said you might have to send out lead agency letters. Usually what you do is you send them out and you give yourself 30 days for those other agencies to respond. If they don't respond, then you assume that they consent to you being a lead agency. If you're in a hurry, you can go and call them and try to get them to respond quicker. And they can, send you letters saying they consent to it, and that can shorten the time. You are almost always going to have to coordinate review for a type 1 action. Next slide. Common agencies you have to send things to include the DEC, Department of Transportation, historic, like SHPO, historic preservation type agencies, Army Corps, SED, agencies like that. Next slide. Usually it involves us drafting a lead agency letter. Involves us, CCing a number of agencies. In this case, the CC list is DEC, 2 different divisions, 2 different permits. You got Orange County Planning here. You've got the Town Planning Board. You've got the DOT. You've got the State Historic Preservation Office, etc. Next slide. Generally, we'll draft it in a way that makes it easy for them to sign, saying they consent to you being a lead agency, and send it back. Next slide. Step 5 is you use part 3 to make a determination of significance. If it's a negative declaration, you're going to determine, and this is the key phrase, that the project does not have the potential for a significant adverse impact on the environment. Remember, anything you checked moderate to large in part 2, which is a issue spotting exercise, means you have to make a decision in part 3. Next slide. So that decision in part 3 is where you make that negative or that positive declaration. The legal test says you have to take a hard look to identify the relevant areas of environmental concern. You have to analyze those concerns, the ones that are determined to be moderate to large, in part 2 of that form. And you got to document why you decided you thought that they were not going to be a significant adverse impact. Next slide. If you do decide it's a positive declaration, then an environmental impact statement needs to be prepared. That's that more regulated process that takes time and involves further study. Next slide. You don't just prepare the EIS. First, you have to scope it, meaning you have to give the public the opportunity to comment as to what issues are going to be studied. Your part 3 is going to identify 1 or more of those 18 questions from part 2 that are going to require additional study. The EIS is not just study everything; it's study the things that you identified as potential significant impacts. Next slide. The statute sets forward, in the draft exactly what you need to include in it. And so there's essentially set forth in the regulations a table of contents. Next slide. You got to get 45 days from receipt of the DEIS for to make a determination of the adequacy for public review. Next slide. Then you have to give the public the opportunity to comment on the DEIS, and you have to give them a certain amount of time to do that. Next slide. And then you issue a final EIS. So you can see if you pause deck something, there's a lot more process. And then there's comment on that. There's a hearing on that. Next slide. And finally, you issue a finding statement where you talk about, balancing the different concerns and how you're going to mitigate any potential impacts that you identified. Next slide. The positive finding statement says you can go forward with the project. A negative finding statement says you can't mitigate the environmental impacts. They're too severe. They outweigh any benefit of the project, and you won't go forward. Next slide. Segmentation says you can't divide a big project into lots of little projects just in order to avoid a neg deck. If you have a capital project, you need to include the impacts of all of the pieces of it when you make your decision. Next slide. And actually, I'm going to go forward because we're running low on time here, I want to get just to the end here where there's some forms I want to show you. Go one more. Okay, so go back one there. I just want to alert you to some of the resources available. There's a SEQRA handbook, SEQRA cookbook, a SEQRA workbook. There's flow charts, the environmental notice bulletin, and there's the DEC website, which I'll give you nice references. Let me tell you a little bit about what each one is. The ENB, I told you this is where you can get information about projects, or you may have an obligation to post notices. The ENB is essentially a section of the DEC website where you are required to report certain actions like POSDEX and type 1 actions and stuff like that. Next, the cookbook is if you feel like your head's spinning listening to me talk about this for 45 minutes and you want to try to look at those 9 steps again, I use the 9-step structure from the DEC cookbook. If you look at the cookbook, it's sort of this level of detail. See, there's like 1 page for each step. There's a lot of flow charts. There's a lot of cartoons and drawings. It's kind of the, seeker from 30,000 feet. And a lot of times, if you're sort of lost where you are in the process, the DEC cookbook is a great way to find yourself on the flow chart. Next. The handbook is next level. A handbook is, 300 pages. It's got a good table of contents that you can use to navigate it. It's structured in a series of questions. This is an example, 1 page of it. Are there any standards or thresholds for negative declaration? Yes, and they answer the question. So they're trying to make it accessible to non-lawyers, and it gives you this sort of that next level of detail. If you have a specific secret question, you can try to look it up in the handbook. Next. Workbook, we're getting more technical. Each one of those questions and sub-questions in the part 2 of the EAF that we discussed has a page in the workbook that tells you, where to get information to evaluate it, how do you evaluate it, what are examples of small impacts in the context of this question, what are examples of moderate or large impacts. So it really goes to that next level of detail. These are usually resources utilized by your attorney or your engineer. Next step. And then just to give you a sense, we talked about the short EAF. This is what it looks like. Next. These are the abbreviated questions. It's not as the 18 questions of the long EAF. Next step. Next slide. You can see their part 2 is 1 page. It's not 18 questions with, each question having multiple questions. So short EAF is a lot easier to navigate than the long one. Next slide. Their determination page is 1 page. Next slide. That's it. So I appreciate your attention. You could do a year-long law school course on SEQRA. So, maybe this 45-minute presentation raised more questions that it answered in your mind, but hopefully this gives you a chance to understand SEQRA a little bit better, to know when you need to ask questions from engineers and attorneys to help you navigate these potential pitfalls, and orients you a little bit in the context of your projects to sort of know where you are in the process and have a better understanding of the advice you're getting from those professionals. And I want to, again, thank you for signing up for this course, and we hope to see you again for future topics, and have a great day.